Hello, good evening and welcome to a program on Law and Order. It's a Friday evening, 9:30, and this is our regular check on the law of this week, where we educate you an area of law. Tonight, we're going to touch upon an area which is very important to all of us, or any of us who is working somewhere to an employer. Simply, I've titled this as the relationship between employee and employer and the law relating to that. To discuss this wide area of law, I have invited an expert attorney on this area. He's no stranger to us. He's been here in other areas of law discussing with us. He's Senaka Sarem, attorney at law. Senaka is a specialist in labor law as well as other areas of law. Senaka, thank you very much for taking our invitation in short notice and coming here. How are you doing today?
Thank you, Chanaka, for inviting me again.
Ending a busy court
yes,
term, right?
We are coming to an end of a court term.
Right.
Yes.
The relationship, whether when you're working as employee to someone, and the relationship an employer who owns a company, how would you define this relationship and how different is this?
Yes, Chanaka, now this would have been very easy to define maybe 20 or 30 years ago. As you know, now people are using smartphones, they are on laptops, they are using internet, they are using intranets. There is a whole system where one need not work in office. So how do you define if somebody is working at home for you? Is he an employee or is he an independent contractor? Those are the general legal terms you use. But basically, are you an employee of somebody? And if so, what are the consequences? So from an employer's point of view, if you are an employee, then you have a lot of obligations in terms of the law, which I think we can discuss today. And in terms of if you are an employee, you have the comfort of having the statutory protections of various payments such as EPF, ETF, gratuity, things like that. Whereas if you are an independent contractor, you are on your own. So the person who hires you has no obligation towards you other than pay for your job that you are doing, and that is it. So the term I would say is whether you are an employee or whether you are an independent contractor.
So, okay. That is like the basic difference.
Basic difference.
Yeah, the consequences of being classified as an employee, if I may put it that way, what would you say?
I think the consequences will be for the employer. Because once you are an employer, you will have to be paying your statutory dues, employees' provident fund, employees' trust fund payments. If you have worked for 5 years, if you have more than 15 employees, you have to pay him gratuity. Then if you want to terminate him, then you have consequences with regard to termination. So all these things will not apply to an independent contractor. So it's difficult now in the modern days in some particular areas to classify who is an employee and who is not. And sometimes you find large organizations, they don't want employees. So now the head count is becoming a problem.
Right.
So then they are outsourcing this.
Right.
They are giving it to other companies. Then they are getting independent contractors to do little work of theirs. So are those people going to be classified as employees? If they are, then the whole gamut of what I told you just now will apply to the employer. So basically, the tests that were used those days are whether he is entitled to work with others, the control test, how much control you have on him, do you provide him with all the equipment he needs to do the work. So that sort of tests were used, but I think those are getting a bit archaic now, which what I told you earlier. So maybe with time to come, with case law coming in, these will be interpreted, and you will have, I think, a case-by-case situation where you will be classified as an employee or independent contractor.
So now the documents that governs employees' employment, is it simply the letter of appointment or collective agreements, or are there more?
Yes, the first document you will be confronted with will be the letter of appointment. So it's advisable for any person, I mean, if you are hiring somebody, even from a company's point of view, or even if you are an employee, to make sure after your interview, what you discussed at the interview is on the paper that you sign. Because sometimes you find that you discuss something at the interview, but you find that it's not there on the black and white paper. So that is the first document you will be confronted with. Add to that, you have large organizations having collective agreements. So that is a negotiation process which may be a trade union or somebody like that. So those clauses in the collective agreement also are part and parcel of your rules. So to add to that, you will have the basic regulations of the company which will come time to time. For example, some companies, they have a thing called intranet, and in the internet you have your computer, you have access to it, and they will upload the necessary regulations which is applicable to you onto the computer. So they will not issue it to you, and in the letter of appointment they will say it's your duty to check the intranet and find out what is applicable to you. So sometimes you are faced with a situation when they want to get rid of you,
Yes.
they use the internet documentation and rules against you. So it's important to know what is in that and what will be applicable to you.
These are also in the situations of union agreements, or we call it collective agreements, then you have more covering than this, is it?
Yes, the union agreement is negotiated with a powerful trade union.
Powerful trade union,
and
yes.
you have weight there.
You have weight there.
So it's
Yeah.
basically a situation where the employee gets the better of the employer, and it's in black and white, so you know what is there.
Right. I just want to divert a little bit and ask, in Sri Lanka, do you have like union agreements in particular trades? Now, if you look at the United States, in the entertainment industry, which we are in, the Writers Guild Association or the Actors Guild Association, whatever, they have unions. These are not people who are particularly employed in any particular area, but it's a subject of employment, right? We'll say you are writers, you are Hollywood writers, 60,000 writers. You can't pay below a certain rate, for example, right?
Correct.
So like that, are there term union agreements in Sri Lanka specified for particular type of employment which are not necessary to particular institutes?
Generally in Sri Lanka it is going as like institutions.
Institutions. Not an industry per se.
Not the industry per se. So basically it has been with one particular employer, there is a collective agreement. So we do not have, I think, generalized situations where there is a collective agreement.
Right. Now, what are the statutes that govern employees, the conduct and everything in Sri Lanka?
Yeah, now you get multiple statutes which govern labor issues, but I'll stick to a few. Like first thing is, as I told you, you will have the EPF Act, that is Employees Provident Fund. Then you will have the ETF, Employees Trust Fund. You will have the Gratuity Act. So these three acts basically will be applicable to all employees. So if you engage somebody, it's a good thing to start paying these dues, because most of even the clients who come to us, they feel, okay, we have employed this person for maybe 3 months, 6 months, we want to wait and see how he is doing.
Yeah.
And they don't make these payments, and later on what happens is these are statutory payments. They have to be paid, and when there is a complaint to the Commission of Labor, the company cannot deal with the situation because the employee has all the details. So then you end up paying even what you call, they impose a fine for not paying. So not only the amount that you had to pay, you on top of that you have to pay a fine also. So because of that, these three statutes are when it comes to employment, these are the main statutes when you have to comply with these regulations that are put out from that statute. Other than those three acts which I told you, if you want to terminate a person or get rid of a person, close down a business, then we have the Industrial Disputes Act and the Termination of Employments Act. Those two acts, I should say, are the main acts. Other than that, I should say, when it comes to the relationship, how employees are going to take holidays, their conditions of labor, you will have the Shop and Office Act, which is applicable to shop and office staff, and you will have the Wage Board Ordinance. So the Wage Board Ordinance is for security services, people in manufacturing organizations, so they have separate regimes.
Right. The Shop and Office Act, I presume, applies to almost all private sector offices.
That's correct.
And shops. Can you explain a little bit about the nature
shop,
of this act?
Shop and Office Act basically will spell out what holidays you are entitled to, and if there is a problem with the condition of labor, salaries, how you have to maintain the registers and things like that. So in case somebody doesn't pay your salary, then the Shop and Office Act will come into play, and the Commission of Labor on a complaint can take it up. So in such a situation, the Shop and Office Act will be applicable, and the Commission of Labor will have an inquiry, and he will either ask you to pay, or he will make a determination with regard to non-payment of salaries.
The EPF ETF Act we just touched upon earlier. Can you explain how does this work for him? Because some employees are confused how much is being cut for EPF, how much is being cut for ETF, what is the contribution of the company, and what is the meaning of that?
The EPF, Employees Provident Fund, basically it's 12% has to be paid by the company, and 8% will be deducted from the employee's salary, and you will remit, the company has to remit 20% to the Commission of Labour, and they in turn, the Monetary Board holds this money till virtually it's a situation where it's given back to you when you are retiring or you are leaving the country, or there are requirements in the act to satisfy for you to get that money back. So the important thing here, Chanaka, is that you do this, because if by chance you don't make these payments and the employee makes a complaint to the Commission of Labour, then not by that time he is not going to refund you the 8% that has to be deducted from his salary.
Exactly.
So then you have to pay to the Commission of Labour 20%.
Yes.
And you have lost out on the opportunity to deduct that 8% from him, because the Commission of Labour is very strict on these matters, and they will tell you it was your duty to remit to us 20%, please pay. And you may have also noticed when you go past the magistrate's court, you have enough and more cases where they enforce this in the magistrate court, and you can't take cover under the company, because the directors are personally liable for these payments, and they will summon you. So it is a situation where I think compliance is, it should be strictly adhered to, and it is good for the company as well, because after all you will be otherwise held ransom by these employees someday who say that no, we don't want these payments, because after all 8% is cut from their salary as well.
Exactly.
And that is a statutory payment, and some don't want that to happen. But once they are not in your good books and once they leave you, they make a complaint. We see this very often. They make a complaint saying that their EPF, ETF or both these payments have not been paid. Then you have no choice. You have paid them salaries, they produce the salary slips, you have no choice but to pay the 20%, and on top of that the Commissioner of Labour will whack a fine also depending on the delay.
Yes.
So it's I think it's advisable to pay this, whatever the period of employment, whatever the caliber of employee. You pay this from the beginning.
Right. Now this, is there a jail term or something for those directors?
There is a fine, and if it's not paid it can be converted. But generally when these matters come up in the magistrate's court, they are virtually settled. So because all the directors are summoned, and sometimes the directors even don't know about this. Sometimes we find where there is a regime change. People have bought companies, and where the previous directors have not paid the money. So of course the Commissioner of Labour is careful, they get the period where non-payment is taken, but sometimes in isolated situations the new directors are also called in, but they had nothing to do with it. So they know, because the pocket is with the new directors, they sometimes summon the new directors as well.
Right. You know, you have a thing called gratuity, and the gratuity is given to the employee, and is there times that gratuity can be deducted, money from gratuity can be deducted? Yes.
Now gratuity, Chanaka, is where you have worked in a company for 5 years. You are entitled to gratuity, and it has to be a company or an entity where you had at least 15 employees. But gratuity, as you said, you are correct. There are instances where the Act provides, where you have done a fraud, or where you have deliberately done some damage to company property. Then there is a situation where you can hold back the gratuity. But there is also a problem in this, because a lot of people don't understand how you can do this. Most of the people, they just wait. Most of the employees, they will do the acts that I told you. They will do a fraud, they will vandalize the company property or some entity's property, and they will immediately leave. Then the company thinks this man has left, he is no longer a problem, and they will let him go. But when it comes to deduction, it is mandatory that we have issued him some sort of charge sheet, held the inquiry, which shows that he has done these acts. So sometimes, most of the time, when we go before the Commission of Labour, the first question they ask is there an inquiry pending? Have you issued him a charge sheet? Have you found him guilty of this? So moment you say no to those things, the Commission of Labour will say no, you cannot do this, and they will refer it to the labor tribunal if necessary for enforcement and ascertaining whether this is correct or not.
Right. Now, what are the statutes that are applicable when an employee services requires to be terminated? I know you mentioned two statutes, termination and this termination process. How does it take place, and what are the general offences a person can be terminated? I mean, these are not the offences on the penal code, but these are employee related offences, or I would say situations. Yeah.
Sometimes, Chanaka, this is stated in your letter of appointment. In big organizations, they have a procedure manual. And as I told you, some developed organizations have the intranet, and they will from time to time inform you what offences will trigger off a situation where your employment is likely to be terminated. So that is when it comes to disciplinary termination.
Right.
So that is a situation where you have terminated the employee on disciplinary grounds. Then you have the other side of the coin, which is where there is no disciplinary grounds, but you are basically closing down the company,
right,
or you are wanting to get rid of these employees. That is non-disciplinary grounds. That is what I was stating to you earlier, the Termination of Employment Act. So you cannot terminate such employees other than without their consent, if you look at section 2, or without the permission of the Commission of Labour. So in such situations, you make an application to the Commission of Labour, and he will decide whether to terminate, if so, how much compensation and gratuity to be paid, and he will give a direction. So you will work according to that. But when it comes to termination on disciplinary grounds, you have to give an opportunity of equal fair play. So basically you will issue him a charge sheet, ask him to reply, and some companies go the full hog, where they will have an inquiry, they will have an independent inquiring officer, they will do an inquiry, and then they will decide whether to terminate you or not.
Is that inquiry necessary in Sri Lanka?
There is no mandatory requirement to have any of these procedures. So big companies have this, and even a decision. Now, for example, Chanaka, if inquiry holds you guilty, and the company says, okay, now the inquiring officer has said that you are guilty, so we are terminating. That employee will go to the labor tribunal and challenge this.
Right.
There is no duty even on the labor tribunal president to look at that report. He may be guided by it, but there is no duty on him to look at it.
Right.
So basically, when you go to the labor tribunal, you will have to prove those charges before the LT president once again.
Right. What is the, now like you said, invariably people who are terminated even with or without the disciplinary process goes to labor tribunal. Now is there a time limit you can go to the labor tribunal?
From the date of termination, it's easy when you say you're terminated. Then from that date where you have been issued the letter of termination, it's a period of 6 months. That is a statutory bar. After 6 months, you cannot go before the labor tribunal. The other problem you have is when you have constructive termination. Like, for example, I will get you to come here, I will not give you work, you will be just seated and waiting, and you will be going on like that. Then what is the period you take for 6 months? So that is a debatable area, and it will depend on the facts of the case. So basically people don't wait 6 months on a chair. So if this goes on for 2-3 months, they quickly go and file application and say that they are constructively terminated. So both the concepts are accepted by the labor tribunals, and they will go on with the inquiry and decide whether he has been terminated justly or unjustly.
Right. Now constructive termination is like one of those grounds that you regularly take for people when they are sometimes even they go on resignation. Now if somebody is forced to resign, can that be a constructive termination?
Yes. Of course, he'll have to prove it. He will have to prove it. So that is another thing that I would like to mention here. Most of the people, they forcibly take a letter of resignation.
Yes.
But then they don't issue a letter of accepting that letter of resignation.
Right.
So these are things that the LT president looks at. So if you have not accepted the resignation, then it's only a letter. And the circumstances in which the resignation has been given. So that is an evidential matter. They will go into it and see whether you have constructively terminated this person, as you say, by force.
Right. Can any employee go before labor tribunal, or the opportunities and employees who has to go before labor tribunal and labor commissioner, the offences or the situations, are they differing?
They are different. Now, labor tribunal is traditionally a situation where you have been terminated on disciplinary grounds. So, you can't go to the labor tribunal and ask for back wages or that you have not been paid EPF, ETF and things like that. So, basically the labor tribunal is to decide whether your termination was just or not, how much if it's just, how much compensation should you be paid, or whether you should be reinstated. That power is also there with the labor tribunal.
Right. The concept of probation. What is exactly probation? Because there are a lot of misconception. And what is the law in probation as it stands now?
The law in probation, Senaka, is basically developed through case law now.
Right.
And probation is a contractual thing that has been included in your letter of appointment. So, you will say you will be given a letter of appointment stating you are on probation for 6 months or 1 year. So,
there is no legal requirement that only this much you can be kept on probation.
No.
Right.
So, the other thing is, most of the letters of appointment does not say that at the end of the period of probation you will be made permanent. So, there is case law to say that if that is not the case, you will continue to be a probationer. So, just because your 6 months ends, that does not mean that you are made permanent. The other issue we have is, now lot of companies, they keep you on probation. If they do not like you, they get rid of you. And then the issue is whether he can go before the labor tribunal. Certainly he can, but then from the company's point of view, you have to be careful. If now you see most of the companies, they come to us, they show an extension of the probation letter. It just refers to that clause in the letter of appointment which says that you are on probation and says your probation is further extended. Now, that is not sufficient. Now, there is case law to show that if you are extending one's probation, you have to tell him what is wrong with him, what developments he has to do in the next period, and so on and so forth, which does not happen mostly in Sri Lanka. They just 1-2 lines and that is it. Very isolatedly good companies, I see they give a long list of things to do, what you have gone wrong, what you need to develop and so forth. So, you can terminate during the period of probation, but and it is difficult for the employee to make a case in the labor tribunal, where he has to show that maliciously he has been terminated. So, if you extended him with reasons, keep writing to him letters saying that you have not developed, then you have a good case in the labor tribunal. And the employee's point of view, if you are getting these letters, if you have been given reasons, then it is time for you to buckle up and work, or you will face the consequences of not having a good documentation to go before a court.
In few words, can you tell me what would be your last advice with regard to the legal framework of Sri Lanka for employees and employers?
Basically, Senaka, a good case in the labor tribunal. And the employee's point of view, if you are getting these letters, if you have been given reasons, then it is time for you to buckle up and work, or you will face the consequences of not having a good documentation to go before a court.
In few words, can you tell me what would be your last advice with regard to the legal framework of Sri Lanka for employees and employers?
Basically, Senaka, we have to get the documentation right from day one. Most of the people, they are having very, I should say, shabby documentation. Even some big companies, they do not have proper documentation for the staff they are working, independent contractors they are working. So, as I said, working today is not employer-employee relationship within the premises. You have outsourcing companies, you can structure yourself. So, I think the main thing is firstly see what you want done, see whether you can structure it through outsourcing methods. If that is the case, you have no headache of all these statutes, employee related problems. And then if you do need to get an employee, have a good agreement, pay the statutory payments so that you can be not at their mercy at any point of time.
Senaka Sarem, thank you very much for those insightful thoughts, and thank you for joining Law and Order today. That's Law and Order for you today. Our topic was employee-employer relationship in regards to labor law. My guest was Senaka Sarem, attorney at law specializing on that area. Next week, we'll have another topic and I'll join you then. If you miss our programs, go to our site channeli.lk and you can watch our shows all over again. Good night and have a good weekend.